Hello, my name is Kelsey, and I am the Early Childhood and Youth Training Specialist for Michigan Alliance for Families. Michigan Alliance for Families is a Michigan Department of Education and Michigan Department of Lifelong Education, Advancement, and Potential, MyLEAP, grant-funded initiative, as well as our state's federally funded Parent Training and Information Center. We provide information, support, and education for families who have children who receive, or may be eligible to receive, special education services. Thank you for joining me for this presentation, Procedural Safeguards, Protecting Families' Rights in Early On. Whether you're new to Early On or have been involved for a little while, understanding your rights is an important part of being an active partner in your child's early intervention services. Here, we'll walk through the protections you have, called procedural safeguards, and explain them in a clear, family-friendly way. We want you to leave today feeling more informed, empowered, and confident about navigating early on. Let's get started. You'll notice several acronyms throughout today's webinar, but there are a few key ones that I'd like you to focus on. By the end of our time together, my hope is that you'll feel comfortable with the following: MyLEAP, MDE, IDEA, MARS, MMSE, IFSP, and PWN. These acronyms will come up often, and understanding what they mean and how they connect is an important part of navigating early on with confidence. I'll make sure we break each one down so they're clear and meaningful. Early On is our state's early intervention system, and it is designed to provide qualifying families with the social, health, and educational services that will promote the development of their infants and toddlers, birth to age 3, with a delay, disability, or pre-existing medical condition. Families and early on providers work closely together to use everyday activities to promote learning so that the child is receiving the best quality intervention based on their individual needs. Early On builds upon and provides supports and resources to assist family members to enhance eligible children's learning and development through everyday learning opportunities. The focus is to support the family so that the child can learn and participate in the things the family does and the places the family goes. In Michigan, the Michigan Department of Lifelong Education, Advancement, and Potential, more commonly referred to as MyLEAP, is the state agency responsible for coordinating Early On. MyLEAP collaborates with various departments, including the Michigan Department of Education, MDE, and the Michigan Department of Health and Human Services, MDHHS, in implementing the Early On system. At the local level, Early On services are delivered through intermediate school districts, ISDs, ensuring that families receive support tailored to their individual needs that may look different in different communities. So where do these regulations come from? The Individuals with Disabilities Education Act, more commonly referred to as IDEA, entitles eligible children with disabilities to special education and related services. IDEA is composed of 4 parts, labeled A through D. Part C of IDEA is early intervention and focuses on helping the family meet the developmental needs of their child from birth to age 3. Early On is our state's early intervention system. All infants and toddlers eligible for Early On are entitled to services and supports detailed for each child and his or her family in an Individualized Family Service Plan, more commonly referred to as an IFSP. An IFSP is a written plan based upon evaluations and assessments, including outcomes goals expected for the child to grow, develop, and fully participate in daily and community activities. Families will receive a copy of their child's IFSP from their service coordinator. Families can request a copy of the IFSP at any time. The service coordinator is the family's main contact in Early On, supporting and assisting the family for the entire time they are in Early On. Each state, including Michigan, must follow IDEA. States can also create additional laws and rules beyond what IDEA requires, so long as they are consistent with IDEA. In other words, states can offer more, but not less. In Michigan, IDEA applies, and so does the Michigan Administrative Rules for Special Education, more commonly referred to as MARS. MARS defines how federal and state laws will be implemented in Michigan. Some infants and toddlers in Early On with greater developmental delays or more intense needs may also qualify for services through the Michigan Mandatory Special Education, MMSE. Eligibility for MMSE services is determined under one of the categories of eligibility within the Michigan Administrative Rules for Special Education, MARS. Any child birth to age 3 who qualifies under MMSE is also eligible for early on. It is important to know that both state and federal governments recognize that families need to be involved in their child's development and education. Research shows that involved and eligible families lead to better outcomes for children. Part C of IDEA lists requirements for early on. You can find more information on these requirements on our Michigan Alliance for Families website or within the Early On Family Guidebook. You can request a copy of the guidebook from your service coordinator. One of your service coordinator's responsibilities is to answer any questions you have on these requirements or your family's rights. For the purpose of this video, we are going to focus on the procedural safeguards for Part C. Procedural safeguards are protections under IDEA Part C, birth to 3, and exist to protect your rights and ensure the early on process functions correctly. This includes all families who receive early on services. Procedural safeguards in the early on system help make sure everything goes well for your child and family and protects your family's rights. Their purpose is to guard your rights and ensure that the early on process happens as it is supposed to for you and your child. Procedural safeguards guarantee that you, as the parent or guardian, are not just involved but meaningfully included in decisions about your child's services. They are built into the early on system to ensure compliance and safeguard the rights of your family and child. All parents are provided with procedural safeguards at key points during their involvement with early on. These rights begin at your first contact with early on and continue throughout your involvement in the program. Service coordinators will review the procedural safeguards with families during the first home visit. By doing so, they can ensure the family has access to the document and that they understand their rights. Your rights apply to any paperwork or interactions with early on regarding your child. It is your right to fully understand all activities and written records about your child. If you require another language or way of communicating, such as Braille or sign language, early on will work to get an interpreter that can use your preferred mode of communicating. By learning about your rights, both you and the early on system can support active involvement in your child's education. Understanding these rights will help you make informed decisions regarding your child's participation in early on. Team collaboration to meet your child's needs is important in resolving disagreements. Let's look at some of the key procedural safeguards. During this video, we will focus on 4 procedural safeguards, which are in place to support you being a fully informed team member and decision maker. Your right to records and confidentiality. The early on record is your family's record. You can see anything in early on's records about your child and family. If you do not understand the way records are written, the information in the child's record should be explained to you in a way you understand. You are a team member and you should have access to the same information as other team members. Early on values the information you and other service and healthcare providers have learned about your child. Early on may ask others for this information but needs your written permission to do so. Just as early on needs your permission to get your child's records from other providers. Early on will assure your records are kept private. Early on's records will not be shared with anyone outside the early on program unless you give your permission. Your right to parental consent. Early on needs your permission to take any actions that affect your child, such as evaluating your child, sharing your child's information, or when starting or changing services. You will be asked to give your consent in writing before early on evaluates or provides services. You want to be sure that you completely understand the suggested activities. By being involved, you can help plan services that match your family's preferences and needs. With the support of other members of your child's team, you will consider which services can best help you accomplish the outcomes that you want for your child and family. You will be asked to give your consent for those services that you want. Early on must explain what happens if you give your consent and if you do not give your consent. You do not have to agree to all services recommended. You can say no to some services and still get the services that you do want. If other services are needed at a later date, you can give your consent then. Your right to prior written notice. Before early on proposes or refuses to start, change, or end services, they must give you written notice explaining what they are proposing or refusing, why, what alternatives were considered, and how you can access help understanding your rights. Early on must give you advance written information about any evaluations, services, or other actions affecting your child. Parents know their children best. The information you share with early on will make sure that evaluations and services are right for you. Prior written notice assures that you have all the details before any activity. Your right to dispute resolution options. Parents have a right to disagree. Maybe you feel you are not being heard, or the plan isn't being followed, or you don't agree with decisions that have been made about your child's identification, evaluation, placement, or services. Early On offers 5 different tools to resolve your concerns. These range from information to formal processes. When we are talking about procedural safeguards, we are discussing protected rights. Procedural safeguards are designed to protect the rights of parents, the rights of the child, and provide families and Early On different options for resolving disputes. Early On creates and keeps a record for your child, which includes things like evaluation reports, the Individualized Family Service Plan, IFSP, notes on your child's progress, and communication between service providers. This record is important because it tracks your child's services, strengths, needs, and goals over time. Your child's record includes any Early On information collected about your child and family. Because every family is unique, the records will look different for each family. Some examples could be for evaluations and assessments. There could be a developmental evaluation showing a speech delay, an occupational therapy assessment measuring fine motor skills, behavioral observations from home visits. In terms of progress notes and communication, it could be weekly speech therapist notes tracking new words, an email from a therapist suggesting new activities at home. And then in terms of those transition documents, maybe it's a transition plan outlining steps for moving to preschool. Could be copies of eligibility documents shared with the local school, or maybe even a list of agencies contacted to support that transition process. Records and confidentiality ensure certain rights. These rights are that your information remains private. You have the right to confidentiality of personally identifiable data, information, and records collected, maintained, or used by Early On. Because many participating agencies and programs may provide services to your child and family during your time in Early On, other agencies and programs may also keep a record of information about your involvement. All participating agencies must follow the procedural safeguards and comply with the confidentiality procedures regarding records. That your information is shared only with consent. Your parental consent is required before any personally identifiable information from your child's record is disclosed to anyone other than authorized representatives, officials, or employees of participating agencies collecting, maintaining, or using the information under Early On, or used for any purpose other than meeting the requirements of Early On. So what could this look like? Maybe Early On asks before sending records to a private speech therapist. Parents signing a release for transition documents to go to the school district, or family refusing consent to share records with another agency they don't know. Early On must keep a record of when they provide access to your child's record, except access by you, authorized representatives, and employees of the participating agency. This record must show the name of the person, the date access was given, the reason access was granted. You give permission to share information by signing a form. By signing this form, you are agreeing that you have been provided with all the information you need to understand why Early On shares this information. You understand the information you have been given. You understand that the information may be shared in writing or verbally. You have chosen what information may be shared. You have chosen who can receive which pieces of information. You do not have to give consent to share information in order to be an Early On. If you choose not to share information, you will still sign a form to make sure this choice is clear. It is important to know that if you decide not to allow Early On to share information, it may limit the ways in which Early On can help your family. You can withdraw your consent at any time. However, withdrawing your consent does not apply to any actions that may have occurred before your consent was withdrawn. When your child leaves Early On, plans for your records to be maintained or transferred will be discussed. That said, there are a few exceptions for when personal information can be shared without your consent. For more information on these exceptions, please contact your service coordinator. You also have a right to review records. You have the right to review your child's records at any time. You can request access to your child's records when you see fit. Early On must provide this access within 10 calendar days of your request. When you make a request to see your child's record, Early On must provide you with access to the record without unnecessarily delay and before any meeting regarding an IFSP or any hearing, and in no more than 10 calendar days after your request. Provide you with a list of the types and locations of Early On records kept by the agency upon your request. Provide you with an explanation of interpretation of the records in response to a reasonable request if you do not understand the records, or allow you to have someone you choose to see the records. So what could this look like? Maybe it's parents requesting a copy of developmental evaluations for their personal files. It could be a family asking to see notes before their annual IFSP meeting. And parents could request records when transferring to a new service provider. You can request a copy of the records, and Early On must make available an initial copy of your child's Early On intervention record upon your request, at no cost. Participating agencies must provide you with a copy of each evaluation, the assessment of the child, the family assessment, and the IFSP at no cost as soon as possible after each IFSP meeting. There may be a reasonable fee for copies of other records, but they can't charge you just for allowing you to inspect them, only for the copies. You have a right to request changes. If you believe that information in your child's record is incorrect, misleading, or violates your privacy or other rights of you and your child, you may ask that the record be changed. This could be a parent noticing a missing therapy session in the attendance record. Maybe the family sees the wrong IFSP date and asks for it to be fixed. Or perhaps a child's name is misspelled in a progress report and they want it corrected. If you ask to have your child's record changed, Early On must decide whether to change the information according to your request within a reasonable time of receiving the request, and either change the record or inform you if Early On refuses to make the change you requested, and that you have a right to a hearing, a formal process used to try and resolve disagreements. When Early On ends for you and your child, your family's record is kept by Early On for a minimum of 7 years and until all of the following are met. Services have ended. Documentation is no longer needed to show federal funds were properly spent. All monitoring activities have been concluded, and there's no request to inspect and review the record remains. The destruction of your child's record may take place once those conditions have been met. Because many participating agencies and programs may provide services to your child and family during your time in Early On, other agencies and programs may also keep a record of information about your involvement. All participating agencies must follow the procedural safeguards and comply with the confidentiality procedures regarding records. We just reviewed why and when families may provide their consent. But what does that really mean? Consent means that you agree and give permission for an activity or action. Your Early On team must get permission in writing, your signature. An important part of giving your written consent means that Early On has your permission and that you are fully informed before providing your signature. Fully informed means you understand what will happen. You understand the benefits, responsibilities, and any consequences so you can make a choice about participating. Informed consent means that you agree and give permission to Early On in writing. Consent must be voluntary and fully informed. You should understand exactly what you're agreeing to. Informed consent isn't just a signature. Your native language, or the language you usually use, must be used for explanations, but it is not required for the written consent to be completed. When you give consent, there is a process to follow, which includes signing a form. Your signature on the form means that you have been provided with all the necessary information. You understand the activity or services for which you are giving consent. You understand that giving permission is voluntary. You may change your mind and withdraw permission at any time. Consent could look like a parent signing consent before speech and motor evaluations. It could be a consent form signed before a hearing screening is conducted. It could be parents agreeing to a reassessment with concerns arising about language skills. Or it could be consent for Early On to collaborate with private therapy agency. Those are just some examples of many. Who can give consent? Consent for early on activities can be given by a parent, an adoptive parent, a guardian, or a person acting as the parent when the parent cannot be identified or located, or when the parent's rights have been terminated. It is important to know when consent is required. Early on must have your written consent, a signature, before any of the following activities may occur. Screening. Before early on can screen your child to determine whether your child is suspected of having a disability. Evaluation. Before an evaluation to determine eligibility for early on. If you choose not to give consent for an evaluation to take place, early on is not able to see if your child is eligible for supports or services. Consent is also needed for any additional evaluations. Assessment. Before assessments to identify your child's unique strengths and needs, and the services appropriate to meet those needs. Early on services. An IFSP is your written plan that describes what supports and services, information, and help you, your family members, and your child will receive. You will indicate your consent to early on services in writing. You may decide which of the recommended supports and services you want to accept or decline. The use of public benefits or insurance. Prior to billing Medicaid or any other public benefit for you on your early on services. Release of personally identifiable information. You should never feel pressured or rushed into agreeing to something. If you have questions, you have every right to ask your service coordinator to give you more information or answer your questions before you sign any forms. You have the right to say yes or no, and if you change your mind later, you can revoke consent, meaning you can withdraw your permission at any time. Parents may choose not to give consent for a variety of reasons. If you decline to consent to evaluation, assessments, or early intervention services, the provider, under Part C of IDEA, will make a reasonable effort to ensure you are aware of the purpose of the evaluation and ensure you understand that your child will not receive an evaluation, assessment, or early intervention services without your written consent. Parental consent is closely tied to prior written notice. Parental consent means informed written consent, such as providing your signature. It is the prior written notice provided to parents that informs parents by completely describing your proposed or refused action and the reasons for it. With prior written notice, you are receiving information. Prior written notice is the right to be told in writing when a change is being made in your child's services, like starting services, changing services, or even refusing something you requested. This gives you time to review what is proposed, understand the reasons, and decide if you agree or want to discuss it further. Again, prior written notice must give parents enough information to be properly informed, meaning it needs to clearly explain what action is being proposed or refused, the reasons why that action is being proposed or refused, including any descriptions of evaluations, assessments, records, or reports used in the decision to suggest or refuse the action, what other options were considered and why those options weren't chosen, information on what the family can do if they disagree with the decision in the form of their procedural safeguards, including mediation, how to file a state complaint, and due process procedures and those associated timelines. So when is prior written notice required? Prior written notice is required for screenings. This is any time a post-referral screening will be conducted to determine whether there is a suspicion of a delay. Refusing initial evaluation for early on eligibility or for Michigan mandatory special education eligibility. This is any time a referral has been made to early on and an evaluation will not be conducted because early on has decided there is not a suspicion of a delay. This includes when screening results do not show a suspicion of delay, or after a parent has requested an MMSE evaluation and the MMSE staff has determined that an evaluation for MMSE eligibility is not needed because there is not a suspicion of a disability that would qualify the child for MMSE services. Proposing initial evaluation. This is any time an initial evaluation is to be conducted to determine eligibility. Continuing eligibility. This is any time an evaluation is to be conducted to determine continuing eligibility. Or after eligibility decision. So any time a decision is made, that a child is eligible for early on and/or MMSE, or anytime a decision is made that a child is not eligible for early on and/or MMSE. Initial or annual IFSP meeting. When early on decides about placement, so service location, or about the provision of service, such as the specific service, length, duration, frequency, intensity, and method of service delivery during an IFSP. Or when a parent declines a placement or service that early on proposed, or for any early on decisions regarding refused proposals for service or placement. Exit or transition. When early on is proposing to end service provision because a child is exiting between age 2.5 and 3 to transition into preschool special education under Part B, or when exiting because the family indicates they no longer want to participate in early on, or when exiting because the child is no longer eligible for early on. So what might this look like? It could be an action being proposed. Perhaps this is an email explaining a proposed change from weekly to bi-weekly home visits with a physical therapist. This could be because their toddler is transitioning to daycare, and the family would like to split the services provided with the PT so that the service rotates each week between the home and the new daycare. In terms of other options considered, the letter may state that the team considered fully stopping PT, but the data still shows a need, and the family would like more assurance knowing their toddler, who can be prone to falls and just started walking, will be safe in this new daycare environment. The procedural safeguards could be included as an attachment to that email, with a service coordinator stating their willingness to meet and discuss any questions or concerns. Let's have another example. How about an action being refused? Maybe this is a written letter. It could be providing notice of the team's refusal to add speech and language services. The letter may state that the parents requested speech to support their infant with bottle feeding, but the team feels that an occupational therapist would be a better fit, stating that an occupational therapist can provide oral motor therapy to support the infant's weakening suck on her bottle due to an illness. The team proposes an evaluation with an occupational therapist. The team also considered a referral to a nutritionist, but the family is not interested in this service at the time. The written letter of notice, along with a handwritten note from the service coordinator reminding the family of the procedural safeguards document she gave them at the last IFSP meeting, and her offer to have another conversation to explain the family's rights and answer any questions they may have. Prior written notice must be written in a language understandable to the general public, and also provided in your native form of language or communication. For more information on these communication requirements, I encourage you to review the Early On Procedural Safeguards Protecting Families' Rights Notice. Families can always reach out to their service coordinator for help understanding notices, consent, or records. You should never be surprised by something happening without notice. If prior written notice was not provided, or if you're not informed of a proposed change to your child's programming, you have all the dispute resolution options available to you. That said, disagreements are natural. When people work together, sometimes they don't agree. The ability to disagree is a family's right, and families have dispute options available to them. If a disagreement happens, there are several ways to address it. The first option is having informal meetings. This tool keeps the people closest to the problem solving the problem, and can be the fastest way to solve problems. If the conversation has been happening between you and a service provider, then you are not able to resolve the issue. It might be helpful to discuss with the service coordinator. Informal meetings allow you to discuss your concerns and issues with the IFSP team. Holding an IFSP meeting may provide an opportunity for you and your child's providers to discuss and possibly resolve this disagreement. You can review or revise an IFSP as needed. You do not need to wait for an IFSP meeting to share your concerns. Another option is a facilitated IFSP meeting. The big difference with facilitation is that a trained, neutral third person facilitates the meeting. The facilitator can keep the discussion focused on the student's needs, address and diffuse conflict, and make sure that all voices at the table are heard. A facilitator can be provided for free through Special Education Mediation Services, also known as SEMS. The third option is mediation. Mediation can help resolve disagreements related to early intervention. such as the student's eligibility, supports, or delivery of services. During mediation, a neutral third-party mediator guides a confidential discussion of the issues. The desired outcome for mediation is a legally enforceable written agreement. Whether there is an agreement reached depends on the participants. If an agreement is reached, the written agreement addresses how that disagreement will be resolved. Facilitation and mediation are both voluntary. Both the parent and school district must agree to participate. A mediator can be provided for free through special education mediation services, also known as SEMS. They use mediators trained in the special education law through local dispute resolution centers. The next two options we're going to discuss are more formal processes. We're going to start with state complaints. A state complaint is a written complaint that is submitted to the Michigan Department of Education. If allegations are pertained to a child receiving Part C services, then the complaint is forwarded to MyLeap. A MyLeap state complaint investigator determines sufficiency and begins the investigation. When filing a state complaint, you are alleging that Early On has violated state or federal special education rules or regulations. Therefore, their determination will be whether Early On was in compliance or not compliance. It is not about right or wrong. From the date the complaint is received, the final decision must be issued within 60 calendar days. MDE will investigate, typically through documentation and interviews, to reach a final decision. If the final decision includes violations, a corrective action plan must be developed to address the violations. There is no appeal to the final decision for a state complaint. There is no cost to the parents to use this option. The most formal option is a due process complaint or hearing. A due process complaint can be filed by a parent, including a parent's attorney, early intervention services provider, local lead agency, or the Michigan Department of Education. A due process complaint may be filed on any matter relating to Early On proposing or refusing to initiate or change any action regarding your child's identification, evaluation, placement, or provision of appropriate Early On services. An administrative law judge, often referred to as an ALJ, is assigned. A resolution meeting is required unless the parent and Early On agree to waive it or Early On files the complaint. The ALJ will conduct an administrative hearing. Witnesses will testify under oath and can be cross-examined. The parties present exhibits and documents and make opening and closing statements. The school district will be represented by their lawyer. The administrative law judge issues a written decision and an order. With a regular due process hearing, the decision and order is issued 45 calendar days following a resolution session. To learn more about the options for resolving disagreements, I encourage you to visit the Michigan Alliance for Families online video library. We have videos on tools for resolving special education issues, special education state complaints, and due process complaint and hearing that provide more detailed information on these topics. You can also visit our website for written resources, including links to model forms. Your rights are not just a formality. They are central to Early On's philosophy. You are an equal partner in this process. Consent is the key to starting anything. Your child's information is protected. You have the right to be fully informed before any action or inaction is taken. If disagreements happen, there are options to work through them while still protecting your relationship with Early On. The more formal the process, the further you get away from the people closest to the problem solving it. The more formal the process, the longer the time frame for the resolution to be implemented. Each of these options has a place for resolving disagreements. Make sure you are using the one that serves your child to get the best resolution. Thank you for joining us to learn more about procedural safeguards in Early On. If you have any questions, please do not hesitate to reach out to your regional parent mentor. We are here to help. You can be connected directly by calling 1-800-552-4821. I also encourage you to follow us on Facebook or Instagram and check out the other videos here on the YouTube channel. You can visit our website for more resources related to Early On, special education, and your family's rights and procedural safeguards. Thanks for tuning in. Michigan Alliance for Families is an IDEA grant-funded initiative of the Michigan Department of Education, Office of Special Education, the Michigan Department of Lifelong Education, Advancement, and Potential, and Michigan's Federal Parent Training and Information Center, funded by the U.S. Department of Education Office of Special Education Programs. Follow-up questions can be directed to us at info@michiganallianceforfamilies.org or call us at 1-800-552-4821. Thank you.